Thank you. The hearing is in the matter of CFI 059-2020 before Chief Justice Zaki Azmi and is being held by way of video conference. Any orders or directions made will be issued by the registry in Dubai on Chief Justice Zaki Azmi's instructions. The claimant is represented by Abdul Hakim bin Hur's advocates and legal consultants. Lead counsel is Mashoud Iqbal. The defendants are represented by Al-Tamimi Company. Lead counsel is Patrick Dillon Malone.
Yes, Mr. Mashoud. How do I address? I think I'd call him Mr. Iqbal. It's easier, is it? Mr. Iqbal.
Indeed, my lord, as it pleases your lordship, Mr. Iqbal is fine.
Yes, we got plenty of Iqbals in Malaysia.
Right, so you've got one more, is Mashoud Iqbal this time.
That's right. Okay.
Okay, my lord, first of all, your lordship would have...
Say, can you see me? You can't.
No.
Now you can see me. Now you can see me. Ah, right.
Yes, now, my lord,
now
yes.
You can see me. Okay, sorry. Yes?
My lord, I can see that the bundle for this hearing is 1,694 pages, and quite frankly,
which I didn't read through. I promise you.
My lord, if yeah, which is why I said, quite frankly, if I were the judge, I would have been petrified, and perhaps I wouldn't have read in whole myself.
Of course you don't.
Yeah, but
yes.
I'm pleased to say that I shall be referring your lordship to just a few pages which appear to be the most relevant pages, rather than going through in and out of the bundle several times.
Now, I want to go. How do I go now? I go to the bundle. How do I go? Oh my God. Where do I go? Okay. Yes, course. And then I'm looking at on another screen. I'm looking at the documents. Hopefully, I don't have this problem of hanging.
Okay, my lord, may I just bring one point to your attention? When your lordship is looking towards your left, then perhaps the microphone is not picking your lordship's voice as it should.
Oh, I see. Okay, now can you hear me now?
Now it's perfectly fine.
Okay, good. I'm trying to retrieve the documents from my iPad.
I see. Right.
Unless you are projecting that on the screen as you submit.
Right. Okay. My lord, I was going to first of all refer to page number 254 in the bundle, or if you can see on the top left-hand corner, there is a PDF numbering electronically. If it's easier for your lordship, you can type electronic number 261.
Where do I do that?
Okay, top left-hand corner of your screen, you can see a very small box on the top left-hand corner. You can type the numbers in that top left-hand corner.
I see case management, top left-hand corner. I don't see anything.
It should be saying, like, for example, 1 of 1694.
This number is 005559 or 56. This one, our case. Our case is 0059.
Yeah, that is right, my lord.
56 or 59.
Yes, that is right. 59. 059. Yes.
059. Wait. I'm not good at these things, you know. 00059, isn't it? 059.
My lord, yes.
Search now. Now I go to case number as judge. Okay. Never mind. You just go ahead. E-bundle.
Okay.
E-bundle. Okay, what is your case number again? What is your page number again?
My lord, that is 059.
059, okay. How do I get to 059? Anyway, just read it and see.
Indeed, my lord. This is the main agreement between the parties. It is, I will call it as heads of agreement.
Yes.
Mr. Justice Jeremy Cook in the Court of First Instance has used the same terminology, heads of agreement.
Yes.
Now, this heads of agreement is between two companies, Fixed Sense and Sunset Hospitality.
Okay, Mr. Akmal, I don't like to disturb your submission, but let me get my facts clear first.
Yes.
This is an application for permission
To appeal
against the decision of Sir Jeremy Cook when he refused your application for immediate judgment.
That is right, my lord. Indeed.
Okay, let's now go on to the basic law on when do you allow or grant an immediate judgment. What are the circumstances? What is the situation where a party will get an immediate judgment? Firstly, there is no dispute in facts.
That's right, my lord.
Right? Because if you read the Sir Jeremy's judgment, he kept on saying that this is factual, it has to be tried.
Indeed.
Okay, what else? What else? Can you tell me what they are? I'm a bit rusty on those points. I'm going to rely on your submission. What are the points where a party will be able or is entitled to be given immediate judgment? Yes, take that.
My lord, yes. I shall refer to the rules of the court.
Yes. You're reading from Rupert Reed, isn't it?
It's number 24, my lord.
You read it from here? Look at
that's indeed the one, yes. Indeed
okay, that's the one. Okay.
It's page number 325, my lord.
325. 325. Okay, 325.
That is.
Let's get the principles correct. Then we can get to the facts.
My lord, yes.
What are the principles? Principles on which the court may give immediate judgment. One. What are the principles? It has been laid down actually in Bank of Ni. One is the must consider whether the defendant has realistic as opposed to fanciful success, prospect of success. If you go into Swain against Hillman, has listed out everything what it means there, say Swain against Hillman. And then realistic prospect or prospect is one that carries some degree of conviction. But before that, the judgment has been established. The principle we apply set out in the. But before that, before you go to even that point, the first few things is the facts must not be disputed.
My lord, yes.
There's a principle thing.
That's
if
right.
If the court finds that the facts is disputable, then it must go for trial.
My lord, yes. Now, I can immediately promise one thing to my lordship, that I'm not going to touch any dispute of fact in my submissions. Neither did I touch any dispute of fact whatsoever before Judge Jeremy Cook. I'm not at all concerned with any dispute of fact.
So you are saying based on all the undisputed facts, there is enough sufficient evidence for the court to arrive in a judgment in your favor. That's what you're saying.
That is indeed correct, my lord.
Okay.
My case is 100% on points of law. I've got 5 legal submissions, 5 grounds of appeal. None of them is about a dispute of fact. But
the judge decided otherwise.
That is the reason we are appealing, my lord.
Okay, can you go point by point on the judge's decision? I think that's better.
My lord, indeed.
Go point by point on the judge's 5 reasons. why he decided against you, and perhaps we can make life easier.
Yes, certainly.
Yeah.
Before I do that, can I make sure that my lord has access to Judge Jeremy Cook's judgment?
Yes.
In the bundle? That judgment can be seen at page number 1 second. Sir. Yes, it's page number 55.
Yes.
It begins with paragraph number 1, the claimant.
Yes.
Okay.
Yes.
May I please invite your lordship to please go straight to paragraph number 31, please.
Yes. Yes. Go ahead. Yeah, go on.
My lord, this paragraph 31 is about cross default clause.
Yes. I'm aware of that.
There are, in fact, 3 main agreements between the parties.
Yes.
First agreement, which is the mother agreement, is called heads of agreement.
Yes.
That requires my client to give certain services to the defendant.
Mm.
And in those services, one of the service is to hold shareholdings in the subsidiary companies of Sunset Holdings.
Okay.
Sunset Holdings has 2 subsidiary companies. Company number 1, Black Tap. Company number 2, Brick Oven.
Okay, Black Tap, Brick Oven, yes.
So, my lord, there are 3 agreements. Agreement number 1, it's called Heads of Agreement.
Yes.
I call it HOA. It's dated 1st of July 2016.
Yeah.
Second agreement, that's Black Tap MOA, Memorandum of Association. Black Tap MOA. Sorry,
Yes.
my apologies. That's Black Tap NA, Nominee Agreement. Black Tap NA, dated 18th of December 2016.
Yes, 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 yes.
And the third agreement is Brick Oven NA, dated 25th of May 2017.
Yes.
Right? Okay. So, first of all, heads of agreement requires my client to hold the shareholdings in the subsidiary companies, and those are Brick Oven and Black Tap. According to heads of agreement, my client did hold 51% shareholding in Black Tap and Brick Oven.
Yeah.
Heads of agreement says that if there is a breach in any other agreement, that breach will be considered as the breach of heads of agreement.
Okay, understood.
This is the cross default clause.
Yes.
This cross default clause is only present in heads of agreement and not present in Brick Oven or Black Tap NAs. As a matter of fact, when the heads of agreement was signed on 1st of July 2016, Brick Oven Company did not even exist.
Yes.
Okay. So the first point, which Sir Jeremy Cook, in my respectful submissions, got it wrong, is this. The defendant says that cross default clauses which are specific to credit security agreements
Mm.
are applicable to commercial contracts as well. That's the defendant's position.
Mm.
I say on behalf of the claimant
Mhm.
that in principle, cross-default clauses can also apply to commercial agreements, but there are some limitations attached to that application.
Isn't that a disputed issue?
That's a legal issue in dispute, not a factual issue at all. Now,
Okay.
in my submission, I brought to the attention of Sir Jeremy Cook authority from the United States Bankruptcy Court, and in that bankruptcy court case, there were a number of agreements. All of them had cross-default clauses.
Of which the Sir Jeremy was not prepared to accept without the argument.
Exactly. Now, that
was he wrong in denying to or refusing to accept your authority as a good authority to support your case?
Yes, indeed, my lord.
You say he was wrong there.
Yes, he was wrong. Now, let me refer you to paragraph number 31. This is why the judge was wrong. If you look at paragraph 31, it is the second line. It was accepted that, in principle, such clauses could apply to other commercial contracts, but it was said that there had to be limits, comma, without any clear exposition of what those limits might be.
Right.
This is where the learned judge went wrong, because I spelt point by point what those other expositions are going to be, and I will show to my lord in my skeleton arguments that were before Sir Jeremy Cook. And in my skeleton, I will just simply take your lordship to that. Just 1 second, please. Yes, my skeleton arguments that were before Sir Jeremy Cook can be seen at page number 478.
478. Four 478. Okay, go. 478. Go. Find page. 478. I cannot get it. That's my problem. Anyway, read it.
Okay.
Okay.
So I will explain the point first of all, or perhaps electronically, my lord. The number is 485. There's the electronic number. If that's
I got 478. No, it's what?
I'm very grateful.
480. What's the number again?
478. 478.
Yeah. I got here 478. It starts with para 848. Is that it? Para 48?
No, it's paragraph 50, please.
Okay, 50. I got here 50. Yes.
In that, my lord can see that I have put 4 different points, A, B, C, D.
Yes.
Right? Okay. These were the 4 points very clearly I put before Sir Jeremy Cook, for example, and I applied them to the facts of my case. That when the heads of agreement was executed, none of the nominee agreements existed. Number 1 point.
Right.
Point 2. The cross-default clause is not inserted in any of the 2 nominee agreements.
Yes.
Point number 3. The heads of agreement and the 2 nominee agreements are not entered into as part of a single integrated transaction. 4th point. Had the cross-default clause been absent from the heads of agreement, even then the bargain between the parties would not have been thwarted. So these were the 4 points. Now let me bring your lordship a few pages back. Let's come back to page number 43, my lord. 476. 476.
476. You must give me the number that I will. 476. Yeah, I got 476 there. Yes.
Now, my lord, in that you can see paragraph number 43.
Yes.
Although on this topic there is no authority from the DIFC court, or even I could not find it in any of the cases in England and Wales, but I managed to find a case from the New York Bankruptcy Court. Now, the facts of that case are in paragraph 44. There were 3 agreements in that case.
Yes.
Mr. Coppell entered into 2 agreements with Campanile.
Yes.
First agreement was asset acquisition agreement. Second was the consultancy agreement. And third was the lease agreement.
Yes.
Cross default clauses were entered into all of these 3 agreements.
Yes.
And all of these 3 agreements were signed at the same time. And all of these 3 agreements referred to the other contracts.
Yes.
There was a breach in relation to the first 2 agreements.
Yes.
Consultancy agreement and acquisition agreement. There was no breach in terms of the lease agreement.
Yes.
Mr. Coppell asked the court to disapply the cross default clause because he said that he had not defaulted the lease agreement. This was the factual matrix, and this is what the court decided. If you look at paragraph 46, my lord, page 47.
Yes. Page 477.
Sorry, yeah, 477, paragraph 46.
Yes, paragraph 46, yes.
This is what the court held. Courts have refused to enforce cross-default provisions in situations where the cross-default agreements are not interrelated. And then it further says, and well, in fact, if I can refer to line number 1, 2, 3, 4, line number 4, 5, 6, 7, thus, comma, where the non-debtor party would have been willing, absent the existence of cross-default agreement, to enter into a contract that the debtor wishes to assume, the cross-default provision should not be enforced.
Okay. How does the facts of those cases apply to our present case?
Exactly. That is the reason that I brought this case. Now here's the fact of our case. Number 1, heads of agreement referred to the cross-default clause, and when the heads of agreement was entered into, Brick Oven Company did not even exist.
Yes.
So the company did not exist. There was no question of my client holding any of the shares.
Excuse me, Chief Justice. I wonder, might I intervene? I'm very hesitant to intervene, but I must take exception on behalf of my client. The court is very unfortunately being misled on this factual issue. It is absolutely crystal clear on the evidence, and it was very quickly picked up by Justice Cook, that the date of the heads of agreement in July 2016 is not the actual date of its execution. It is the absolute position on the evidence that the agreement, the heads of agreement, had not been entered into as of the 12th of April 2017. And I believe it does fall short of the requirements of this court for this not to have been brought to your attention, and this has been repeated 5 times already.
I realize that, Patrick. Mr. Patrick, I don't know how do I address you, Mr. Patrick Dillon. I realize that, but let us hear what Mr. Iqbal has to say, and then when it comes to your turn, I know he's taking a big long time, but I don't want him to be left saying that I didn't give him
very good
opportunities to say what he wants to say. So let him say what he wants to say, because and that is why, as you can see from my questioning him, I'm asking him over and over again, you know. So let's hear what he has to say. Maybe he can convince me, you know. And well, let's hear about it. Okay, Mr. Iqbal, go ahead. My question is how those facts of the New York case apply to the present case, such that the court is bound or should follow your submission or should grant you that immediate judgment. Okay. Firstly, the judge must first decide, yes, I agree to accept the principles laid out in the New York case, which is not a Commonwealth case. And I do not know what the law in New York says apart from that decision. What are the basis on which the New York judge arrived at that conclusion? We do not know. Without further delving into the facts of that case, applying that facts and delving into the laws of that in New York and applying it to us. There's so many things to do, you know, before we can say, okay, I follow the New York. You know, so I can hear bear what Sir Jeremy's mind is working when he's asking this decision. Nevertheless, Mr. Iqbal, I'll give you a chance for you to submit what you want to say. Tell me, convince me. Tell me on the balance probabilities that you are right.
Yes,
you are
I'm grateful. I will come to my learned friend's point after I've answered your lordship's point. Now,
yes.
Can I please, first of all, the New York bankruptcy case is a common law jurisdiction. That's number one. Number two, my lord, if I can please refer to page 477, where your lordship already. It's paragraph number 47, please.
Yes, I am there.
That's the point of principle.
The court analyzed the cross default clause in the lease agreement by examining the relationship to the note and held, indeed, the documentary evidence leads to the inescapable conclusion that the note and the lease are essential. Is that what you're reading? The note, according to the affidavit, is another essential part of the bargain for the sale of that. Yeah. Okay.
My lord, again, yes, because your face was facing elsewhere, so the microphone did not catch your lordship's voice.
Sorry. The reason is I'm reading from. I thought my face is quite close to that. I'm reading from the screen which appears on my iPad. That's what. Yeah, I was reading that clause just now. 47, paragraph 47.
It's paragraph 47. Say now in that. The court says, number one, that the note and the lease are essential agreements of a single transaction in Recopel's case. And then you see the note, according to affidavit, is another essential part of the bargain for sale to the debtor. Campanile asserts in his uncontroverted affidavit that Copel understood and accepted the unified nature of the transaction. Unified nature of the transaction. Now, let's take these 2 points. Number one, essential part of the bargain, and number two, unified nature of the transaction. These are the two requirements for a cross-default clause to apply in commercial agreements. This is what the authority says. Now, Sir Jeremy Cook said that he does not find this case helpful because it's in another jurisdiction, in company's court. Right. Number one, the point is this, It's a legal proposition. It's a point of principle. It's a point of general application in commercial contracts for cross-default clauses. There are no conceptual limitations attached to this point that it can be taken in bankruptcy and cannot be taken in other commercial agreements. Sir Jeremy Cook did not give even a single reason why conceptually this point should not be applicable to DIFC courts, which is also a common law jurisdiction. So
because he felt that it should be left to the trial court to decide.
Now this is my point. The point is
okay, go on.
Yeah, the point
is go on. Yes, sorry.
Yeah, the point is this. In this particular case, it is not in dispute that when the heads of agreement were entered into, one of the companies did not even exist. Now, my learned friend Mr. Patrick Dillon Malone took the point that the heads of agreement were not 1st of July 2016, and he said he just proposed 12th of April 2017. For a moment, let's accept what my learned friend says is correct. I'm not getting into a dispute of fact. Let's say he's correct. Even then, Brick Oven was not incorporated until 3rd of July 2017, 3 months later. So my learned friend's intervention, although passionate, respectfully was misplaced, because even if he's right, it doesn't take him anywhere except interjecting my submissions. So the point is this, that in this particular case, there's no dispute of fact. It's a common ground that the Brick Oven Company was incorporated 3 months after the heads of agreement. Now, for argument's sake, let's say if Brick Oven had never been incorporated, still the heads of agreement would have been capable of performance. So the point is, the cross-default clause on the facts of our case is not present in all of the agreements, number one. Number two, it is not a unified transaction. Number three, in the absence of the cross-default clause, the bargain between the parties would not have been thwarted. And number 4 point, I've already said that the cross-default clause is not inserted into all of the other agreements. So these are the 4 points. So Jeremy Cook told me that without any clear exposition of what those limits might be. Well, I gave very clearly those 4 expositions, and my lord did not address that in his judgment. He ought to have addressed it. Secondly, if this case of Recopel is irrelevant, then reasons should have been given that why this is irrelevant. And number 3, if this case, my case, raises disputes of fact, then they ought to have been highlighted by Sir Jeremy Cook, and then he should have said that because of these disputes of fact, this case gets no help whatsoever from Recopel. That did not happen. So, my lord, that's my first ground of appeal, and I'm not going to elongate my submissions. Unless I can be of assistance on this first ground, I seek your lordship's leave to move on to the second ground.
Yes, please do so.
My lord, the second ground is this. Heads of agreement requires my client to hold 50% shareholding in Brick Oven and Black Tap. Well, in fact, heads of agreement did not name which companies, but it says hold shares in subsidiary companies. Heads of agreement requires my client to hold 50% shares in those companies, whereas the nominee agreements of those companies require my client to give that 50% shareholding away. So what the heads of agreement is asking my client to do, the other agreements are asking my client not to do. So that's the point. The point is, if I comply with heads of agreement, I fall foul of the nominee agreements. If I comply with nominee agreements, I fall foul of heads of agreement. So either way, I am the one who is going to be injured. It's the case of either the knife falls on the melon or the melon falls on the knife. It's the melon that's going to get a cut. That is the case with my client. If she had performed, she would have been bitten. If she had not performed, she would have been equally bitten. Now, that is the point that I put before Sir Jeremy Cook, and Sir Jeremy Cook said, well, apart from this other point, there are, or maybe, other services. Now, for example, it's paragraph number 33 of His Lordship's judgment. If I can quickly make a reference to that, and then I'll move on to ground 3. My Lord, it's paragraph 33 of the judgment.
Yes.
Sir Jeremy Cook said,
What page is that?
my Lord, that is page number 68, please.
68 or 068? 68.
68.
Fine page. Okay, 68. Yes.
It's paragraph number 33.
33. Yes.
Just in the middle of that, line number 1, 2, 3, 4, 5, 6, 7, 8. Line number 9, my Lord.
Yes.
The heads of agreement was capable of application to services provided as and when requested by Sunset RAC, whether for other subsidiaries yet to be incorporated or otherwise.
Yes.
Yet to be incorporated. Let's say if Sunset RAC would not incorporate any companies, for example, where would I stand? I stand nowhere. So the point is this, that the most important service that my client was to provide was to hold 51% shares in subsidiary companies. And the subsidiary companies want her to transfer those 51% shares to somebody else.
But follow up with Sir Jeremy's statement in para 34.
Yes.
What did he say? In my judgment, therefore, Sunset RAC and Sunset have a realistic prospect of success in their defense.
My Lord, yes, that is the conclusion reached by Sir Jeremy Cook, and it was not open to His Lordship. And these are the 5 reasons.
You are saying he has arrived at the wrong conclusion.
Indeed, and not just one reason. I've given 5 reasons. This is my second reason that I'm on at the moment.
Yes.
Now, if I can quickly refer your Lordship to the heads of agreement, and once again, I would like to come Patrick's passionate point that he had earlier made. It's page number 254, please.
254. 54. Fine page. Okay, 254. I've got 254.
That is legally binding heads of agreement.
Yes.
Okay, if we scroll down to the end of the page, fixed sense services.
Yes. Yeah.
Okay.
Fixed sense is a shareholder.
That's right, yes. It's the third line. Services shall primarily be limited to Sunset Holdings only.
Yes. Yes.
And then we can see at the end of the page, there's little a. So the first service shall be a shareholder for the registration of 51% shares in Sunset Group companies. That's the first. This is where everything starts. Once she holds 51% shares, then B comes into play, liaising with all governmental and semi-governmental bodies. And then in the position of 51% shareholder, she can represent the Sunset Group for number of purposes. And then having 51% shares, she can do developing, preparing, and carrying out of the business. So the point is, if she doesn't hold 51% shares, she cannot do B, C, and D.
Yeah, but if it's post trial, not stop you from proving all this again. Are you stopped from prevented from raising those issues at trial?
My lord, I apologize. I apologize. The audio is not clear.
I said that if this case goes for trial, full trial, you are not prevented from raising those issues again anyway.
My lord, the point is that
you want to do a shortcut. You want to do a shortcut and get an immediate judgment, or what in England we used to call summary judgment without going for trial. That's what you're saying.
My lord, the point is, when there is no dispute of fact, why should we go to trial? These are the points of law.
But the judge thinks otherwise.
Well, it was not.
There is a finding of the judge. So even if there is an appeal, on this application, your appeal against the refusal of immediate judgment, what is the likelihood of the appellate court deciding?
Yeah, my lord,
is there a likelihood of the appellate court deciding to say, oh, we have decided on this and therefore immediate judgment is given? Or is the appellate court likely to say, the judge has found this as fact in his judgment, we are not going to interfere with that, go for trial? I have to be satisfied with that. I have to be satisfied that your likelihood of success in the appeal is whatever term they use in the law. Anyway, go ahead.
My point is that on the facts of this case, without raising a dispute of fact,
yes,
the defendants have no defense in law. So why should they be allowed to go to the trial? That is the whole purpose of immediate judgment. My case is that my case is unarguable on the points of law. There is, therefore, no need to waste the court's time to go to trial. That's the whole purpose of immediate judgment. That is why we made the application. Yes. Anyway, so, well, because your lordship is already on page number 255, if I refer to page number 258, please.
258. 258. Fine page. Okay, 258. That's the end of the page.
Yes, you can see just above this stamp, fixed stance, your lordship can see a date. We confirm our agreement to the terms set out above on 1st of July 2016.
Yes.
That's what this document says.
Yes.
That's where I picked up the date, number one.
Yes.
Number two, even if Mr. Dylan Malone is correct to say that 1st of July 2016 is not the correct date, but the correct date is 12th of April 2017, even then, it gives him no pleasure, because, let me refer to page number 285, please.
285.
285.
285. Fine page. Yes, that is the heading, first page of the agreement.
Yes, that's exactly. So the point is that Brick Oven Agreement was signed on 25th of May 2017.
Yes.
3 months after the heads of agreement. Well, even more to that, not just stopping here, if I could very quickly take to one other point, and that is page number 240, please. If we go back, 240.
240. Fine page. Yes. Yes.
My lord, this is the Memorandum of Association for... Sorry, 1 second. Yes, Memorandum of Association for Brick Oven, And your lordship can see that it was on 3rd of July 2017 when Big Brick Oven was incorporated. 3 months after, even if Patrick is right. So, anyway, that's the point that I've addressed to my learned friend. Let me move on to ground number 3, my lord. Okay, now my ground number 3 is that there was no agreement on price between the parties. Now, for example, let me take once again to page number, 1 second. Okay, my lord, once again, page number 285, please, if I can quickly.
285. Yes.
Now, 285 is the brick oven agreement.
Yes.
And if we scroll down to paragraph number 3.1, please.
Yes. Consideration.
Consideration. There is an amount mentioned of 72,000 Arab Emirati dirham.
Yes.
Okay, that's for brick oven. However, if we come back just a few pages, scrolling back to page number 280, please. We can see another consideration. That's for black tap. It's 10,000 AED.
Yes. 10,000 AED. Yes.
10,000. Okay. Now, my lord, if I can now find, which is the last page I'm referring to. That is page number 438, please.
438. 438. Yes.
Now, this is the email coming from the defendant, and the email says, second line, as agreed yesterday, we have changed the sponsorship amount to 10,000 dirhams. However, also as agreed, we acknowledge that this is symbolic, and we still need to find a final agreement.
We still need to find a final agreement.
So the agreement on price was reserved between the parties. This 10,000 and 72,000 pounds, that was not a consideration. It's a symbolic point. So the point is this, that for the nominee agreement to be legally enforceable, there must be consideration. And the claimant, the defendant admitted that this 10,000 is symbolic. So no consideration, no legally enforceable.
Let me read again. As agreed, we have changed the sponsorship amount to 1,000 dirhams. However, also as agreed, we acknowledge that this is symbolic and we will need to find a final agreement over this, whether in the form of shareholder in Sunset Group or an agreement for this outlet. Please let you know if we collect a signed copy of document today. Okay.
See, so something not agreed upon between the parties. Sir Jeremy Cook ought to have taken that into consideration. If he had taken that into consideration, then he would have been forced to find that the nominee agreements are not binding. That's the whole point. Now, if I can refer to the judgment of Sir Jeremy Cook, please, paragraph 27, page 66.
Page?
Page 66, my lord.
66. Shit, what happened? 66. 66. One page. Yes.
If you look at paragraph 27, please. Fixed Sense argues that cross-default clause only operates if the nominee agreements are enforceable, which they are not by reason of A, B, C, D. Now, for example, my lord, let's ignore A, B, and C. Let's forget that. Just focus on D. The uncertainty as to the fees payable. That was the argument I raised before Sir Jeremy Cook. So Jeremy Cook says these matters are all highly disputable. Well, the point is about the fees. There's no dispute. The defendants.
What the other 4 points?
Well, have a look at A, B, and C. A is misrepresentation, including their conclusion.
Yes.
I did not raise misrepresentation point before Sir Jeremy Cook because that's about dispute of fact. So I did not touch that.
Yeah, if there's a dispute of fact, he has to go to trial.
I beg your pardon?
If there's a dispute of fact, he has to go to trial.
That's right. That is why
Yeah.
that is why I did not raise the misrepresentation point before Sir Jeremy Cook. I didn't raise it, and I do not raise it.
Yeah, but it's there. That's mention about misrepresentation if it is not in the pleadings or say affidavit or something like that.
The point is that in the particulars, there is a dispute as to misrepresentation. We did not ask the court to give immediate judgment on that point.
No, you say that.
No,
point to be decided in the whole case. The immediate judgment is for the order that you sought for. What was the orders that you sought?
My lord, no,
what were the orders you sought?
My lord,
what were your orders you sought?
Okay.
Read the orders that you sought.
My lord, yes, I will take your lordship to my skeleton arguments in support of my application.
No, don't go there. Go into your pleadings. What were you seeking for?
My lord, I was seeking for a summary judgment to be granted in respect of a number of paragraphs.
Yes.
Out of the defense.
Yes. But the defense says, no, I don't agree to a number, the causes of action you're seeking for. They don't agree. And the judge has been in between, has to decide whether you are right or the other party is right. And in doing so, he has taken into consideration all these matters.
My lord,
that's how you arrive at this conclusion.
My lord,
you cannot say I don't raise it. The judge cannot raise it. The judge, of course, can raise it.
My lord, okay. Well, I think there is a confusion. Can I please refer to page number 20 in the bundle, please? That will answer all the questions.
Mr. Iqbal, I can just sit and say nothing and then make a decision. But I was being very fair. I throw you a lot of things which are moving in my mind. I tell you now what is in my mind, giving an opportunity for you to explain.
My lord, right? Can I please respectfully invite your lordship to hold your observations until I have completed my 2 other points.
Okay. Well, no, I'm not made my decision yet. I'm not heard the defense. I have to hear the respondent first before I make a decision. But what I'm trying to tell you, what is going in my mind, I'm telling you, please answer that. Please answer that.
Yes.
Because I want to give you the opportunity to answer. Okay.
Lord,
what page do you want me to go just now?
Yes, my lord, it's page number 19, please.
19, okay.
It's paragraph, it's paragraph number 20. That was my application for the relief.
Yes. What is it?
It is therefore submitted that the following paragraphs must be struck out of the defense, because they disclose no reasonable grounds for defending the claim. And then your lordship can see I struck out one sentence from paragraph 5, all of paragraph 30, 31, 52, 64.7, 65, 66, 69, 70, and then paragraphs 32, 53, and 56. And on the basis of that, if you look at paragraph number 23, please.
23.
And 23.
Page what? Page
21.
21.
Yes.
21. Okay.
Paragraph 23. And accordingly, Fixed Sense respectfully invites the court to uphold the claim for causation, loss and damage to the extent pleaded in paragraphs 49 all the way to 49.8 of POC. That is the relief that I asked for, and all of these paragraphs did not raise dispute of fact. These paragraphs are not touching the point of misrepresentation. I was very clear in my written submissions.
Okay.
Sir Jeremy Cook, only for the sake of completeness in his judgment, referred to misrepresentation. Well, the point is so simple. Only the first-year student of an LLB can understand, I think, that immediate judgment cannot be granted on dispute of fact such as misrepresentation. I never asked for that. I do not ask for that. I will not ask for that. All I said, strike out these particular paragraphs from the defense because in the eyes of law, they do not have realistic prospect of successfully defending the claim. What we said to the court, strike these paragraphs out. The remaining point of disputes of fact, for example, misrepresentation, let that go to the trial. That was my case. So
Yeah, you want to go misrepresentation to go for trial.
exactly, we
Your
said
own
it.
way.
We have to accept it. We said it. Let misrepresentation go to trial. But
Hmm.
on the other points, for example, lack of consideration, for example, unenforceability of cross-default clause, for example, public policy of UAE law, these are all the points of law. So insofar as the points of law are concerned, strike out relevant parts of the defense and allow the remaining part to go to trial. Now, that's where the confusion is removed. I will
Wait. Are you the defendant or respondent? Sorry.
I'm the claimant. I'm the
You're the
claimant.
claimant. You're the claimant.
Yes.
You're the claimant. How can you ask the court to strike off the defense? You have to file a special application, immediate trial to strike off the defense.
We did.
How can you put in this your argument and say strike out the defense? It's not your business. It's for the defense to decide. I want to put my defense.
My lord, we asked for number one. We made an application seeking two reliefs. Relief number one, we asked for certain parts of the defense to be struck out under 3.42 because they do not disclose reasonable defense. In the alternative, we asked for immediate judgment under RDC 24. Well, that's the usual procedure, either or. We made one application seeking two reliefs in the alternatives. I can show the application, and that application is here at page number, 1 second, my lord. Yes, it's page number 1, please.
Yes, page number 1.
Yes.
Page number 1. Go to page. Okay, page number 1. Yes.
The paragraphs 5 to 30, all the paragraphs of the defense are struck out, and number 2, that there be an immediate judgment for the claimant in accordance with paragraphs 47.1 to 47.4 of the particulars of claim, and number 3, costs. And then because number 1, that these paragraphs of the defense are struck out as they disclose no reasonable ground for defending the claim. And
were they struck off?
The judge refused to strike them out. That's
what. The judge refused to strike off because he thinks that is a defense. Go for trial. That's why he refused to strike off.
My lord,
he refused to strike off, the defense stands. The defense stands means there is a issues to be tried.
My lord, that is why
I'm being very fair with you, Mr. Iqbal. I'm telling you what is in my mind so that I give you the opportunity to explain.
My lord, I'm very grateful.
I'm not my decision. I'm not my decision. I'm deciding just on points that you raised.
My lord, first of all, I must say that your lordship is being very fair, gracious, and patient with me, and for which I feel indebted. And
Indeed.
I'm going to be very quick now to close my submissions, and I'm coming to the two last points.
Yes, please.
It's ground number 4.
Ground number 4. Are you reading from Jeremy's judgment?
I can, and
Okay.
that is
okay. What page is that?
my lord, that is page number 67, please.
67. Okay.
Paragraph 30.
30. Yes.
That's right. Now, Fixsense argued that there was no guarantee by Hannah Al-Hers to abide by the default cross-default clause in the heads of agreement.
Yes.
Now, my lord, heads of agreement was signed between Fixsense, which is a company, and Sunset. Hannah Al-Hers, who is the claimant in this case, was not a party to the heads of agreement. And when the heads of agreement were signed, Brick Oven did not even get incorporated. So Hannah Al-Hers is a party to Brick Oven nominee agreement. Brick Oven did not exist when heads of agreement were signed. Also, Fixsense never required Hannah Al-Hers to enter into a contract to either hold the shareholding or transfer the shareholdings. So that's the point I put before Sir Jeremy Cook, and in paragraph 30 we can see that Sir Jeremy Cook did not give clear or adequate reasons to disagree with me. That's my ground 4. Unless your lordship requires my further assistance, I seek your leave to move on to my last, and that's the last ground, which is ground 5.
Yes, please.
My lord, ground 5 is simply this. UAE federal law requires that it must be UAE nationals who must have at least 51% shares in UAE incorporated entities. That is the reason Hannah Al-Hers held 51% shares in these two companies. That's in compliance with the UAE law. The other two agreements, Brick Oven and Black Tap nominee agreements, they require her to give that 51% shareholding away. Now, that we say is in breach of the UAE law, and let me refer you to one last page, and that is page 437, please.
437.
437.
Yes. I can't see. It's too small. Yeah. What is it? What does it say?
Yes, 437, my lord. That is an email.
Yes.
Dated 23rd of May 2016. Now, in the middle of the page, which is in,
yes.
Your lordship can see in blue.
Yes.
Hi, Antonio. Thank you for sending us through Miss Al-Hers's legal comments for our review. The clause relating to DIFC courts is standard in such agreements and should remain DIFC courts does have jurisdiction over the agreement as parties are free to enter into an agreement. Bullet point 2. We are aware the agreement may not be enforceable for public policy reasons. So the point is this. The agreements, which is Black Tap NA and Brick Oven NA, they require Ms. Al-Hers to give away 51% shareholding, and the defendants admit that it may not be enforceable for public policy reasons. Now, Sir Jeremy Cook said that in order to decide this point, which I say is a point of law, facts should be explored at trial. My point is simple. Something which is in the eyes of law is against the public policy consideration of the UAE, and moreover, the defendants also indicate that it may not be enforceable. Then what a point of sending it to trial? For that reason, we asked that the defendant's defense, the relevant parts must be struck out insofar as they relate only to the dispute of law. And in relation to the disputes of facts points, please let them go to trial. That was my case before Sir Jeremy Cook. Now, Sir Jeremy Cook said, let everything go to trial. That is where I have a grievance, and which is why I am asking and I'm knocking the Court of Appeal's door. Please let me in and put all of these points before the full court, because each of these 5 grounds of appeal are, number one, each of the grounds have realistic prospect of success in the eyes of law. Secondly, each of those points are points of general public importance or important points of principle or practice on which DIFC, either Court of First Instance or Court of Appeal, has not yet made a ruling. So the Court of Appeal must avail this opportunity to give authoritative guidance on each of these 5 points of law. Unless I can be of any further assistance, once again I express my gratitude for your Lordship's patience and kindness towards my submission.
Thank you very much. Thank you very much. We will now hear Patrick Dillon. Patrick? Yes, Patrick.
I think Mr. Dillon, you may be mute.
Thank you very much. Chief Justice, I think I'll be about 35 to 40 minutes.
Yes.
I don't know whether we should take a break or should I keep going?
No, please go on.
Thank you.
I think we may take a break after your submission. We
Yes,
may take a break after you finish yours.
Just to begin at the beginning, the pleadings in this case are themselves demonstrate what an extremely high hurdle the claimant has on this application. In their particulars of claim, they seek declarations that we were not entitled to terminate the heads of agreement, and they also seek orders of specific performance and damages. And of course, the grounds of our defense, which are interconnected with the issue in the related proceedings, are that the nominee agreements were breached. That triggered the default clause, and we were entitled to terminate the heads of agreement. In turn, the other side say, no, the nominee agreements are unlawful, or the cross-default clause is inoperative. And that for reasons which themselves are bound up with the facts and depend in certain respects on very complex matters of public policy. So the pleadings, for example, if you look at the defense, I won't open unless you ask me to, Chief Justice, but if the defense at paragraphs 28 to 30 and 43 and at paragraphs 67 to 76 demonstrates how connected this case is and our defense is to the core issue in the related proceedings.
Can you
And
briefly tell me what the 28 or 67
that
what do
in
they say?
in the related proceedings, we have sought to compel Ms. Hertz to transfer the shares to another UAE national.
Yes.
Following our requests. She refused to do so. Those requests were made in November, December 2019. She refused to do so. We brought what we thought would be quite a simple specific performance action. But to that, the defense was raised that no, the nominee agreements are void for reasons of public policy. And that is on the claimant's own case. And you can see it in the reply at paragraphs 29, 31, 34, 39, and 40. Multiple times in the reply, you can see that there are references by the claimant to say that, no, we're not entitled to our defense because the nominee agreements were entered into by fraudulent misrepresentation. By fraudulent misrepresentation. You can see that.
There is the pleading by the claimant in their reply.
Yes, at paragraphs 29.1, 31.2, 34, 39, and 40. And they also say that on their own case, they have sought the consolidation of these proceedings with the other proceedings, in which the issue of whether the heads of agreement or the nominee agreements are contrary to public policy is squarely an issue. So finally, on the pleadings, Chief Justice, from the reply at paragraph 43, you will see that the defense, that the claimant claims that our defense is fictitious and a concoction. So here we face our reliance on agreements, which I'll come to the facts in a minute, which are undisputed, but that the background of our termination of the heads of agreement, the key facts to that are not in dispute, and I'll come to those. But we're faced with claims that we have been fictitious and made up things in our defense, that we procured the agreements by fraudulent misrepresentation, and that the agreements themselves are void for public policy. And these issues undoubtedly were correctly highlighted by Justice Cook below. It's not the case that he just included references to those complex issues of fact and law by way of completeness. He very correctly took the entire pleadings and issues into account. And in that context, judged that the striking out of our defense, of those portions of our defense that had been sought by the claimant, was not an appropriate matter. None of them were appropriate for summary determination. So if I could just come...
Sorry, I interrupt you there. But Mr. Iqbal is saying that his claim or his application for immediate junction can be decided without looking on those disputed facts, even if there are any. That's what he says.
Well, that's not correct. Then the court must clearly have regard to the entire pleaded cases. And also, the judge did not actually miss out anything. He very carefully took account of all of Mr. Iqbal's arguments, and that's fully reflected in the judgment and in the dismissal order reasons and the reasons for refusing appeal. And I'll bring the court to that, obviously. We rely very much on the judge. We believe that Justice Cook actually very, very completely took on board all of the arguments of the other side, and these are reflected very fully in the judgment. There's nothing, he didn't miss a trick. But if I could come to the facts, because there is, I'd have to say, Chief Justice, regrettably, a disconnect with reality in the persistence of the claimant on these 5 points of appeal. No account at all is taken by Mr. Iqbal in the pleadings or in his submissions to you today of the actual reasons given by Justice Cook refusing permission. So they just not one reference to that. There's no engagement either with the logic or the reasoning of the original judgment of Justice Cook in January. It's as if he didn't speak at all. There is just a simple verbatim repetition of the same arguments that were put before the judge, and there's no reference to the change in the law, of which this court, I'm sure, will take judicial notice, that as of yesterday, the Article 10 of the UAE Commercial Companies Law has been changed. And that, again, is just a disconnect from reality. It is well known and is certainly going to be a point of importance in the actual hearing of these proceedings, of these joint proceedings, that the Commercial Companies Law has changed. And that obviously has an impact on the public policy issue. I have to say again that the disconnect with reality is also reflected again in the insistence or the not resiling from the claimant's position that the date of the recorded date of the heads of agreement is in some way significant. It's absolutely clear on the evidence that, and it was swiftly picked up by Justice Cook and correctly pointed out in the judgment at paragraph 6 of the judgment, that the heads of agreement were entered into after the 12th of April 2017. And contrary to yes, I think I'm going to anticipate your question, I hope. Yes. Contrary to the submission of Mr. Iqbal, it makes no difference. It's legally and it's irrelevant that the nominee agreement was entered into after the heads of the, or that the company had not been incorporated. And that is also reflected in the judge's reasoning. And the reason is quite simple, because it's quite clear that the heads of agreement is an umbrella agreement. It anticipates the formation of companies. It anticipates that there may be none or many nominee companies, nominee arrangements. But I'll come back to this again, Chief Justice. It's worth saying that the definition of services under the heads of agreement, of course, isn't confined to the actual holding of the 51% shareholdings. There are other services that are provided. And of course, the claimant was paid for those services handsomely for so long as the agreement was in force and up to termination. There was significant payments of the fixed fee and of the anticipated profit fee. It's in the evidence, and it's certainly north of 1 million dirhams was paid to the claimant and Ms. Hertz for their services. So I can find that reference again for you. But the idea that price was not agreed, it was agreed, and the judge correctly found that it had been agreed. The reference to the fact that there may have been at one point an anticipation that different payments might have been arranged, that he's on the facts. Again, remember, the judge made these findings not for the purposes of saying, I find for sunset on this issue. He said, of all of the arguments about vagueness and invalidity, they all were highly disputable, and in fact, they are all highly disputable. But he picked out the payment issue. And in the payment issue, he said, actually, when you look at it, it was certain. And actually, the money was paid. And therefore, if anything, he would have found that as a matter of summary judgment for us on that issue. But he didn't need to do that. He just said simply, these are all matters that in any event require to be investigated at the hearing, as they undoubtedly do. So if I could come back to you, Justice, because I think it is important.
Well, what do you have to say to Mr. Iqbal says what he's asking for doesn't depend on the finding of facts of those matters raised by Mr. Justice. It is not relevant. He says, what I'm asking only this declaration, why do you have to go into the facts? That's what he's saying. Even though those facts not disputed, or even disputed, is not relevant to what he's asking for.
But he's simply wrong about that, Chief Justice, and the judge was right. And I'll come to it on a point by point basis to explain why a factual investigation is required, and in certain circumstances as to why, even if the issue were determined on the facts in favour of Mr. Iqbal, as you anticipated in one of your questions, it doesn't make any difference to this court on appeal at this point against a refusal of a strikeout application, because even if there might be an argument that the facts could be determined in favour of Mr. Iqbal, or that the facts are not actually relevant, that it's a pure issue of law, it doesn't get him to the point of a strikeout or an immediate judgment. So I think if I could just take a step back for a second, because I think it is important. It's reflected in the judgment, and were the arguments that were before, on the facts that were before Justice Cook at the first instance. And they were that the ordinary and natural meaning of the cross-default clause was that, in fact, a breach of the nominee agreements would enable my client to terminate the heads of agreement. And that is not appealed. That finding of Justice Cook below is not appealed. The plain meaning of the construction of the language, which took up quite a bit of time below, that's not before you. It's also not disputed, and never was disputed, that Miss Hertz is a 99% shareholder of Fixed Sense, of the claimant. It's also the case that the nominee agreements were entered into by her with entities forming part of the Sunset Group, and that's the language of the cross-default clause. And it's also quite clear and undisputed that on our case, on Sunset's case, the heads of agreement was terminated because Ms. Hertz refused, she breached the nominee agreements on our case because she refused the November-December 2019 requests to transfer the shares to another UAE national. And of course, Justice Cook astutely reflects that in his judgment. There's no question of the request itself being in breach of any public policy. The wider issue on the fifth ground of appeal here is whether the agreements as a whole, considered together, in some way offend against UAE public policy. And that obviously is a massive issue which requires investigation. So those were the agreed facts. Now there are other, or the facts that were not in dispute, or now is on the construction of the clause, is the absolute case as found by the judge, which is not the subject of appeal. There are other facts which still do require to be investigated at trial, and we'll come to those. Now, of the grounds of appeal, there are 5 grounds. 2 of them are what I call the invalidity grounds. That's the idea that the nominee agreements are contrary to public policy. And indeed, as Justice Cook pointed out, if the nominee agreements are contrary to public policy, there's the heads of agreement, there's an argument that the heads of agreement are contrary to public policy. They're all part of the same thing. And you can see at paragraph 5 of Justice Cook's judgment that he absolutely, it's worth reading that at paragraph 5. I'll just read it to you, Justice. The end, it's page 56. At the bottom, the final few lines, he describes the overall contractual arrangements in the previous paragraphs. And he says the interconnection is obvious, but their exact interrelationship is the subject of dispute. Mr. Iqbal, for Fixed Sense, described the HOA as the mother agreement, and it seems that the nominee agreements were entered into in the light of it, or of a similar overarching arrangement which preceded its execution, whatever their timing. And so the judge below was entirely satisfied of the interconnection, the interrelationship. They were all part of the same thing. And he goes on to find that the cross-default clause was an unnatural arrangement because it very sensibly protected my client's position in something which was at the heart of the performance of the services under the heads of agreement by the claimant and by Ms. Hertz. So the other point then is that the second invalidity argument is the argument that the agreement is in some way void for uncertainty about the payments. I'll come back to that. There are then three inoperability grounds, and they're grounds 4, 1, and 2. I think I've lost you now, Chief Justice, on the camera.
Yeah, sorry.
Okay. So grounds 5 and 3 are the invalidity arguments. Grounds 4, 1, and 2 are the inoperability arguments. And perhaps I can start, Chief Justice, if I take them a little bit out of the numbering 1 to 5, if I may. Yeah. On ground 5, I mean, it's on Fixed Sense's own case. It's quite clear that it's not suitable for summary determination. It's actually the case that Mr. Iqbal has made and that is made in those submissions manifestly demonstrates that this is entirely unsuitable for the public, whether these agreements, these entire arrangements conflict with the public policy is a complex issue which requires investigation of the circumstances in which these agreements were entered into, how they were operated in practice, whether there was any actual breach of the public policy requirement for 51% to be held, which of course we say there wasn't. And I don't think it even arises on an allegation. It seems to be a theoretical type of allegation. But the other thing is that paragraph 17 and 18 of Justice Cook's judgment are impeccable on this issue and unassailable.
Can you show that to me on what page is that?
It's page 63.
Yes.
It's paragraph 17 and 18.
Yes.
And starts on page 63. Whether, as it appears to have been suggested, the whole scheme of nominee arrangements breach the public policy which underlies the commercial companies law raises difficulties which require full exploration and would not necessarily assist Ms. Hertz. Reliance was placed on emails passing between, etc. And I'll just skip back to the reference to these emails and herself, which appeared to show an awareness of a risk in the arrangements being made for nominee holdings. And of course, this is what was open to you today, Chief Justice. The heads of agreement itself refers to Fixed Sense providing local sponsor-related services with respect to the nominee ownership of shares in UAE companies in order to meet the requirements of the CCL and to the provision of services as may be permitted by law, as and when requested by Sunset, and to one of the services as being the holding of 51% of the shares in Sunset Group companies in order to ensure compliance with the CCL. The very terms of the head agreement, apart from the nominee agreements, therefore raise the same public policy issues as the nominee agreements themselves, if such there be, and any court would undoubtedly consider the whole scheme as set out in the different contracts, as well as the correspondence and exchanges between the parties in determining whether what was done did breach the law or public policy considerations. If the nominee agreements are void on that ground, must be a strong argument for saying that all the arrangements between the parties are void also, which would mean that any claim based on the heads of agreement might well be considered unenforceable. And I suppose what Justice Cook is here spotting is that ultimately there could be a curse on all our houses if Mr. Iqbal's public policy arguments were to come home, because it would be a Pyrrhic victory for his client. 18, if such arguments are to be raised and in oral, this aspect appeared to play a greater part than in prior written submissions. Full exploration of the evidence and the law and public policy be needed, which cannot be effected on an immediate application. And if I then refer you, Chief Justice, to page 74, this is the reasons of Justice Cook, and you'll see at paragraph 8, the bottom of the page.
Wait. 74. Paragraph 8.
The final ground advanced.
Yes.
And I won't read that, Chief Justice. I'll let you read it.
Yeah, okay. 74.
And it's paragraph 8 of the reasons.
Okay.
If I could just refer over the page to the end of that paragraph.
Yes.
As appears from the term of the HOE and the nominee agreements, which expressly referred to the need for compliance with UAE laws on foreign ownership of UAE companies, difficult questions arise as to the consequences of any finding of illegality or public policy in relation to the differing provisions of various agreements. And in that regard, the Justice Cook correctly highlights that the agreement itself says that that law must be complied with. The law must be complied with, which leads to the question then, if there was any non-compliance, it must be an investigation on the fact. It would be wholly inappropriate to determine any issues of illegality and public policy without full consideration of all the relevant facts and circumstances, which can only be done at trial. And we say that is impeccable reasoning, it is unassailable, and that Justice Cook was alive to all of the matters, including the abstract character of the challenge of Mr. Iqbal's client. So if I could move then to ground 3, Chief Justice. Oh, sorry, I should say, Chief Justice, it is important that I bring this to your attention, and I think you can take judicial notice of it, that the law has changed. Article 10 of the Commercial Companies Law has changed, and you'll see the present version of Article 10 is at page 1375 of the bundle. And the decree is also at page 1519. 1375
of the bundle. Yes.
That is,
yeah.
Now this raises obviously an issue for these collective proceedings. There is a very real issue as to whether the complaint that is made is moot in the light of the change of law, and certainly that is again a complex issue which would require full argument before the court below. Again, the failure of the complainant to make reference to that is extraordinary. It is a matter of notoriety in the UAE that this is an extremely important development in commercial practice and the law, and obviously it has an impact on Ms. Hertz's livelihood and business as she performs nominee services. So if I could move then to ground 3, the judgment, if I could again refer you to page 66, you'll see it's dealt with at paragraphs 27 to 29 of the judgment, starting at the bottom of page 66. And we've been through this, so hopefully I don't need to spend much time on it. But you'll see the judge, as I've already mentioned in my opening, he picks out the issue of the uncertainty of fees. not as an issue that is likely to be determined on an immediate judgment in favor of fixed sense, but as which, on his view, on the justice below's view, on his observation, most likely actually would be capable of being determined on its face in my client's favor. And he reasons that there was a price paid, there was a price agreed, and also that the price was paid. And that
You're frozen. You're frozen. I can't hear. I can't hear you, Mr. Patrick Dillon. Maisa, I can't. We can't hear Mr. Patrick Dillon. Can you
yes, Judge,
communicate?
I will ask. Yes, I will call him now.
Yes,
Hello?
Mr. Dillon.
Can you hear me?
Yeah. Can you repeat the last few sentences? You went frozen. We couldn't hear you. You're frozen again.
How annoying.
Ajas, can you help? The privilege.
Hello?
Yes.
Can you hear me?
Yes.
Okay, I'll keep going. My colleague is contacting the IT department, but I'll keep going if I may, Chief Justice.
Can you reverse for the last few sentences? I missed them. We missed them.
We were referring to the fact that Justice Cook had picked out the point at 27D, not for the purpose of saying that this is a matter that could be determined in the claimant's favor, but on his reading by way of observation, he says, well, actually, if anything, I think that's a matter that could be clearly determined in favor of my client, not in favor of Mr. Iqbal's. And the reason he gave was, number one, it's quite clear there was an agreement on price, and that's set out in the agreement. And number two, it's clear on the evidence that there were payments made. So the fact that there may have been a discussion at some point about other payments is neither here nor there. But those were observations. He didn't find as a fact that that was the case. He just says it as to bolster his reasoning that these are all matters that require investigation. So even on the other side's case, that these agreements are invalid or inoperative for these reasons, the uncertainty of fees one would, if anything, go against them, but they all require investigation of the facts. And again, the judge's reasoning at paragraph 28 on the question of payments demonstrates that he fully took on board the arguments of Mr. Iqbal. And including the question of whether it was symbolic. as he says, although described in correspondence as symbolic, with a further agreement anticipated, there's still no uncertainty as to the fees payable because the agreements themselves do identify a price, and the facts show that a price was paid. And in that, again, to the extent that Mr. Iqbal still has an issue with that, that's a matter for trial. In relation to that particular point, yeah, then you'll see it's picked up again at paragraph 74, or sorry, at paragraph 6 of Justice Cook's dismissal order on page 74.
No, before you proceed on, Mr. Malone,
Yes.
Mr. Iqbal did say that give us the judgment that we sought, but you can, the rest can go for trial. I'm not very clear on that. Can you assist me?
Well, I think that he's not correct about that, because the portions of the defense that are sought, the most important portions of the defense that are sought to be struck out, include our defense that we were entitled to terminate the heads of agreement.
Yes.
So if we're knocked out of our core part of our defense, which is that actually we were entitled to terminate the heads of agreement, then that includes all of these matters that are the subject of inquiry, that need inquiry. The public policy issue, all of these 5 points, in fact, are relevant to either the invalidity or the inoperability of the agreements which we seek to rely on. So that's not, it's just simply incorrect that any of these be surgically removed from the case without substantially impacting on my client's defense.
Okay, go on to you were ground what? Ground 3 or 4?
And we rely again on paragraph 6 of the second judgment, where he says, concludes, there is no basis for any summary finding here which could have assisted the claimant. And that's a very neat summary of the judge's conclusion on point 3. There's no basis for any summary finding here which would have assisted the claimant. And we respectfully agree with that and say that the judge was plainly right and correct in that conclusion. I move now to the inoperability grounds. The first ground I'll take, if I may, is the ground 4. What is said that there was no guarantee, no privity between between Ms. Hertz and my client, and that in some way that the tripartite agreement that were the subject of the cross-default clause shouldn't be the subject of a cross-default clause because privity is required at all times. But that's just the argument we made below, and which was accepted by the judge, is that the default is external to the relationship of the parties, and freedom, the clear words of the clause have a clear meaning. The parties, as a matter of freedom of contract, were entitled to provide for this cross-default. As the other side accepted, it's a common feature of commercial agreements. And the judge further found that in the present case, it made entire sense for my client to protect itself by providing in a cross-default clause for the ability to terminate the heads of agreement in the event, as indeed happened, that Ms. Hertz were to abdicate her responsibility under the nominee agreement and under the heads of agreement indirectly as the shareholder. So on this point too, we've got the date question again, and I need not go over that again. The clear provisions provide that under the heads of agreement, the cross-default clause will apply to Ms. Hertz as a shareholder. And in addition to the express language of and it's undisputed that she is a shareholder, and in addition to that express language, we have the evidence of the contractual negotiations. And if I could refer you to page 1220, which is the email sequence on the 12th of April 2017, which Justice Cook relied on and had regard to in his judgment. And here you'll see that the wording of the cross-default clause is being negotiated by Mr. Marwan on behalf of Fixed Sense. And they changed the language from specific language specific to Ms. Hertz to language which encompasses her as a shareholder. And so you have this under the DIFC contract law, if needed. Of course, Justice Cook did not find it necessary, and I don't believe you would find it necessary to go beyond the express language of the clause itself. But if you did, you have this very, very contemporaneous evidence as permitted by the DIFC contract law, as interpreted by this court, to show what the intention of the parties was. And the idea that there was no guarantee, that a guarantee is required, is just a completely misconceived argument. There is no requirement to enter into a guarantee for a relationship of guarantor when one has a tripartite arrangement of this sort with agreed cross-default provisions which were negotiated with the parties. And the judge correctly relied on the freedom of contract of the parties and correctly pointed out that no authority or principle had been identified by Mr. Iqbal which would constrain the freedom of contract of the parties in that regard. And we rely on paragraph 30 of the judgment and paragraph 7 of the dismissal order. Those are at pages 67 and 74, respectively. I won't go beyond them. Of course, the way in which Justice Cook dealt with this, again, very pithily, was to say, well, look, you're missing the point again. The entire purpose of the default clause is to trigger guarantees in the absence of privity, is to trigger an ability to treat the default of one agreement as between A and B as the default between another agreement between B and C. That is their purpose, and that's freedom of contract. So if I could then turn to the fourth ground, which actually is ground 1, it's in relation to the New York case. I'll try and be quick on this.
Page again, sorry.
It's the New York case. If you look at page 55.
55, okay, thank you. Yes.
You see at the very bottom, very last line, I have had the benefit of considering that paragraph 3. He says, the judge said, I have had the benefit of considering. You see that?
Yes, the claim form.
I have the benefit of considering, and then flip over the page.
And ask defendants together with number of authorities, including New York authorities. Yeah.
Including New York authorities. So the judge specifically says that he's had the benefit of considering the New York authorities. And then he goes on, if you could turn please to page 67.
Yes.
And you'll see we've just referred at paragraph 31 at the bottom of that page to the principle of freedom of contract. And you see the judge there said that Mr. Iqbal had submitted that there had to be some limits without any clear exposition of what those limits might be. And the judge starts by saying, well, look, actually, in principle, as a starting point, that we have the principle of freedom of contract. And then he goes on over the page, paragraph 32 and 33. Or sorry, just 32, to address the question of the New York authority relied on. Now, what he says is, first of all, he says that there's nothing disproportionate in the protection of the sunset company's legitimate interests. And he goes on to point out that it appears to be a necessary protection. And the reason why the judge makes that conclusion there is because Copel was originally relied upon for the proposition that there should be some proportion, some rule of proportionality. But in fact, later, the argument appears to be, well, actually, Copel requires at least there be a connection between the agreement. And if I could refer you then to page 73, Justice. And if you look at the entire description of in paragraph 4 of the reason Justice Cook. About 6 lines down, he says, it was specifically accepted by the claimant that in principle, such clauses could apply to other commercial contracts. In other words, non-security contracts, albeit subject to some undefined limit. As I stated at paragraph 31 of the judgment, no relevant authority was cited in support of that proposition in respect of a clause which, to my mind, was clear and unambiguous. I referred to the reliance placed by the claimant on New York case relating to insolvency, which included recopal, which in itself is illustrative of the special considerations by in the context of insolvency, when reliance is placed upon cross-default clauses, whether otherwise the bankruptcy rules or set off would not apply. And he refers to the claimant's skeleton. And what's very interesting is that the judge goes on to say, well, look, this idea of it being disproportionate or unconscionable, that's not the argument anymore. It seems to be cited because they must be interrelated. The agreements Mr. Iqbal was saying and the argument that Mr. Iqbal made to you today is that they must be interrelated. Now, in fact, what happened in Copel was that the judge found, that the New York court found, that the agreements were interrelated. And notwithstanding that it was an insolvency context, the cross-default clause was actually enforced. And so, if anything, Copel supports my client because on the construction of these agreements, actually, they're all part of the same transaction. It's quite clear from Justice Cook's treatment in the first judgment and in the second judgment here that how interrelated those agreements are. And I'll go on to this. This is at the bottom of paragraph 4 on 73. On any view, as set out in my judgment, the agreements which are the subject of dispute here are all closely interrelated, although the exact nature of the relationship is in dispute. The reality is that any question of unconscionability, disproportionality, and interrelationship in relation to these agreements and the cross-default provision is a fact-sensitive issue, and there's no clear issue of principle or law relating to such clauses which could justify a summary determination on the inapplicability of that clause in the heads of agreement to the alleged breaches of the nominee agreements. This ground of appeal has no real prospect of success. And again, that reasoning is unassailable in our respectful submission. How could it possibly be correct for this court to say that the application of an argument that the heads of agreement and the money agreements are disconnected in a way that would allow the cross-default clause to be voided or avoided by this court. How could that be done on a summary application without inquiring into the law and the facts? And Chief Justice, you already said yourself, I would need to know more about New York law, but certainly you need to know more about the facts and about what the parties said about how these agreements were interrelated.
Yeah, but it finally goes back to when I started this hearing today, this morning for you and this afternoon for me, that when does a court grant immediate judgment? You have to go back to that. Immediate judgment is not easily given. Striking off and summary. We used to call it striking off and summary judgment. I learned as striking off summary judgment. The court will not strike off a defense or a claim unless it's really satisfied that there is no basis for the claim or defense. And same with summary judgment. It will not grant any summary judgment unless the facts are all very, very not disputable at all. Whenever there's a doubt, the court inevitably will send it for trial. And there, parties can voice out whatever they want to say in detail. That's what I learned in school.
Yes. At the risk of, I'm sure, not educating you any further, but at least giving you the law at your fingertips, I hope. Could I give you 2-page references for the law? In relation to the test to be applied under RDC 24.1,
yes.
If you please look at pages 748 to 751. Not now.
Yeah, no, I'm just taking that. 748 to 751. Okay.
That was our skeleton argument at first instance.
Thank you very much. It's also
December. And Judge.
Yes.
Judge, might I also refer you to pages 678 to 680.
678 to 680.
Which is our submissions in opposition to appeal dated 26th of April. And there we set out the test that you would apply as an appellate judge.
Yes.
So those for your test.
I'll read them. I'll read them.
Thank you very much. And each of those submissions then continues on to apply those standards, and we rely on our submissions in those regards.
Good.
Just 2 very small points, if I might, very quickly before I leave COPEL. The definition of services, the definitions of what's anticipated in the services and the formation of agreements, all of those contractual provisions in the heads of agreement and reading the nominee agreements together with the heads of agreement demonstrates that the judge was undoubtedly right, Justice Cook was undoubtedly correct, and certainly not wrong to the required standard for disturbing his finding. That there is a strong interrelationship between these agreements and they're all part of the same transaction. And then if I could move to the final ground, which is this sort of strange idea, which is being again revived before this court, that there is a contradiction between the performance of obligations under the nominee agreements to transfer shares to another UAE national, that then, in the words of Mr. Iqbal, kills the heads of agreement. And this is an entirely incorrect and misguided submission. The way in which the judge dealt with it as well bring you to it, that paragraph 33 of the judgment and paragraph 5 of the dismissal order. So if I could bring you to page 68. About 5 lines down after the semicolon, he says, nor is there any inherent contradiction between the provision of clause 5.5. Common clause 5.5 of the nominee agreement was the obligation to transfer shares on demand, and the continued existence of the heads of agreement. If Ms. Hertz had transferred the shares as requested, there would be no further shares held by her in Black Tap and Brick Oven. But the heads of agreement was capable of application to services provided as and when requested by Sunset Rag, whether for other subsidiaries yet to be incorporated or otherwise. The termination of the arrangements under the nominee agreements did not automatically bring the heads of agreement to an end, although the heads of agreement provided that it would remain in force for an unlimited period. That did not mean that the nominee agreements in relation to Black Tap and Brick Oven could not be terminated, as was plainly envisaged by the terms of clause 5.5 and 6.2. And that's undoubtedly correct, Judge, because the Miss Hertz a fixed sense still gets its payment under the heads of agreement, even if there are no nominee agreements. And you'll see in the agreement itself that there's provision for a fixed of 40,000 dirhams per month and an anticipated profit fee, which is 41,000 dirhams per month. And I referred earlier to the substantial payments that have been made during the life of the heads of agreement to Fixed Sense, and that is in the evidence in the main proceedings. So this is an umbrella agreement. The heads of agreement is an umbrella agreement. It envisages that, oh yeah, we may have different companies. It's not the case that Mr. Iqbal mentioned earlier that there were just 2 subsidiaries. Maybe it was just a slip of the tongue. Of course, there are more subsidiaries, and again, that's in the evidence. The fact that these nominee agreements come to an end doesn't mean that there might not be other nominee agreements. It doesn't have any legal impact on the force of the heads of agreement, which is stated to be unlimited and to remain. So it's really a difficult ground of appeal to understand. I mean, on their own case, Mr. Iqbal says that the heads of agreement was the mother agreement, and you know that underneath that mother agreement, then one would have, as envisaged, nominee agreements, and plainly it envisages their termination in the event that my client decides to direct, as contractually agreed, the transfer to direct Miss Hertz to transfer her shares to another UAE national, and that was what was done here. And the definition of services, again, we rely on that. You'll see that at page 59 to 60 of the judgment.
Yeah.
You see that it's also set out maybe a little bit more neatly in Mr. Iqbal's own skeleton at page 1646. But you'll see it in the agreement itself, of course. And the agreement is at page 1119. 1119. If I could just actually bring you to that, Justice, if I may. 1119. You see the services definition is provided, and then over the page to 1120. And it's not correct, as Mr. Iqbal submitted, that B is dependent on A. It's not. I mean, there are different ways in which services can be provided, and indeed representing the Sunset Group, developing, preparing, and carrying on any business development. All of those are services that are provided for and anticipated, and the agreement was terminated by my client for breach of the very serious breach of failing to abide by the lawful and agreed direction of my client to transfer the nominee shareholding to another UAE national. So for all those reasons, Chief Justice, it is my respectful submission that none of these grounds of appeal are matters that can be determined on a summary disposal. It's impossible that it's inconceivable that this court would, maybe not impossible, but certainly inconceivable that this court, with any three of your colleagues, would completely depart from their senses and grant immediate judgment on any of these grounds of appeal. Some of them are really difficult to understand. Certainly the Copal argument, the idea that the compliance with the transfer direction kills the agreement, and the idea that there's a guarantee. In fact, one could say that certainly 4 out of 5 are difficult to understand.
Okay, Mr. President, if you say that there is no prospect of success at the appeal, even if it is granted, what about that other reasons? The clause says about prospect of success and any other special reason. Isn't there any special reason why I should allow this permission?
Thank you very much, Judge.
What are the points of law, important points of law that the Court of Appeal can use this to sort of
yes.
to allow or to determine?
Yes. I think the simple answer to that is to again adopt the approach of Justice Cook. He found that, of course, there are compelling reasons why these matters should go to trial, the public policy issue. And that's a compelling reason why it should go to trial. And that was his approach. I mean, the interconnection of these particular portions of our defense with the other portions itself demonstrates how difficult it would be to bring these up on an immediate judgment and just deal with those before the Court of Appeal and leave everything else behind. In fact, if this appeal hadn't been taken,
what you're saying that those issues can be decided at trial as well, and if necessary,
100%, and everything is still in play. Everything is still in play, but not on an immediate judgment application. The compelling reason that we, of course, when one is talking about striking out our defense, one is talking about a trial going ahead anyway, but without those portions of our defense. So, is there a compelling reason why the trial should go ahead without our points of defense, or is there a compelling? It's impossible to see. But I think Justice Cook reversed the question, and that's the correct approach, which is to say that where one has difficult and complex issues of public policy mix, and now we have this mootness question in the middle of that, and all of the interrelationship of the two sets of proceedings, which on the claimant's own case were joined and not consolidated, but they're certainly going to be case managed together from Justice Cook from here on. In fact, the irony is, Chief Justice, that if this appeal had not been sought, we could already be very close to a trial in both cases by now.
Okay. So thank you very much, Mr. Impan. Would you like to reply now, Mr. Iqbal?
My lord, yes. My learned friend initially said he would take 30 to 35 minutes. In fact, he has taken over an hour. In fact, more than me.
Perhaps it's my fault for interrupting him as well, Mr. Iqbal. Doesn't matter.
This wasn't a criticism of my learned friend's eloquence. I certainly did benefit from his attractive submissions. Regrettably, those submissions are incorrect massively. and there are these 5 bullet points in which I will summarize my reply. Number 1. My learned friend criticized me for not addressing Sir Jeremy Cook's reasons for refusing permission to appeal. My lord, as I understand, the procedure is that I am seeking permission to appeal against the judgment of Sir Jeremy Cook refusing to grant immediate judgment or strikeout. That's the decision before you, not the decision refusing permission to appeal.
Wait, Mr. Iqbal. The present application is an application to seeking permission to appeal.
That's right.
Right?
Right, yes.
And that is because Mr. Justice Cook has refused that application to appeal.
Correct.
Right.
Indeed.
So how do I view now? Do I view Justice Cook's refusal to appeal, or do I view his judgment to refuse immediate judgment? Right now sitting like Jeremy Cook, as Jeremy Cook said, to determine whether permission to appeal should be granted, and now should I be sitting in his chair now making that decision?
No.
Or should I be looking at Sir Jeremy's decision to refuse your application to appeal?
No. My lord, this court, if permission is granted, and even today, is to review Sir Jeremy Cook's decision refusing to give immediate judgment.
Yes, right.
Slash strikeout. That is the reason I did not waste this court's time by addressing the reasons for refusing to grant permission to appeal.
Right.
My learned friend expected me to do that. That would have wasted the court's time, and I did not do that. Hence, I did not address my lord on that. That's one.
Never mind. Yeah.
Thank you, Chief Justice. I think this is important. There is an appeal notice at page 76, which is the appeal notice against the 10th of January 2021. And then there's also an appeal notice at page 689. Yes. So there are 2 appeal notices, I think. Okay. Now, it seems that one notice was filed after the Justice Cook refused permission. But we have no difficulty in principle that what this court, and it's certainly the way I was approaching it on our side, was that you are actually reviewing the refusal of immediate judgment. But in relation to that, I maintain my position that Justice Cook's review, in accordance with the correct procedure of this court, the application was made to him in the first instance. He gave a reasoned judgment on the order. And you can't just ignore that. I mean, he has been back, reviewed his own judgment, and he's given those reasons, and they're cogent and compelling.
Yeah, but it also means that I have to read his original judgment.
Of course.
Whether there are grounds for appeal. You know, it's just not looking at his application to appeal, but his ground, whether I like it or not. I've got to go to that ground in order to say, there are factual facts in dispute, this, before I can. So I'm sort of sitting in the same chair as Justice Cook's in deciding this application to appeal. But it does not stop me from looking at Justice Cook's reasoning and saying, I agree or I don't agree. Right? Am I right there? Good. Thank you very much.
I completely agree. That is the correct approach, my lord.
Yes, yes.
Now, again, making best use of my limited time. Point number two.
No, there's no limit. You go ahead. You go ahead. Don't worry.
My lord, I'm once again extremely grateful and obliged for your patience. Thank you.
Yes. Yes.
Point number two. I'm grateful to my learned friend for educating us that the UAE Federal Law Section 55 has been amended. Now, what impact does that amendment have on this case? Because this was initiated before that very amendment. This is a question for the Court of Appeal to determine if permission to appeal is granted. Therefore, this is one of the compelling reasons why permission to appeal should be granted. This is point number two. Point number three. My learned friend has spent considerable time on RECOPEL, and for a number of times he has brought to your lordship's attention the term interrelated or interconnected agreements. And my learned friend also referred your lordship to Sir Jeremy Cook's reasons for refusing to grant permission to appeal, wherein Sir Jeremy Cook used the term that these are interrelated agreements. And therefore, Mr. Dylan Malone has mounted an argument that RECOPEL is in his favor. With greatest of my respects to Mr. Dylan Malone, that is a completely misconceived reading of RECOPEL. RECOPEL gives a two-stage test. There are two questions in RECOPEL, which, if answered correctly, only then a cross-default clause can apply to commercial contracts. Question number one. Looking at all the agreements in question, can it be said that all of these agreements are unified in nature, bearing in mind the transaction? So that's question number one. Unified nature of the transaction. Not interrelated or interconnected. There is a great gulf between interrelated and unified nature of transaction. That's number one. Two, whether or not, if the cross-default clause is struck down, would the bargain between the parties be thwarted? That's the second question in RECOPEL. What my learned friend said, interrelated, interconnected, that has got no relation to the ratio decidendi of RECOPEL. And what Sir Jeremy Cook said in his reasons refusing to permission to appeal is not correct reading of RECOPEL. Therefore, this is a second reason why permission to appeal should be granted, and the Court of Appeal in DIFC should give an authoritative judgment in this part of the world. Now I come to my third reason. My learned friend again repeatedly submitted that payment had been made to Fix Sense, and I remember my friend saying considerable payments had been made to Fix Sense. But what is being ignored is Fix Sense is a legal entity completely independent of Hannah Al-Hers, who is an individual and is the claimant in this claim. So any payments made to Fix Sense under the heads of agreement cannot be equated to payments made to Hannah Al-Hers in person. Again, these are completely two entities, One is a legal entity, other is a natural person.
Isn't that the dispute be more suitable to be determined at trial?
My lord, yes.
Bothering me. It's bothering me, Mr. Iqbal. It's
Yeah.
really bothering me. Yes.
No, I agree. My lord is right. There's a considerable force in your lordship's point.
Yes.
I would have, well, it would have completely shut my mouth had this been the only ground of appeal. I would have come before your lordship. This is not the only ground of appeal. So what I submit, that even if your lordship says that, yes, Mr. Iqbal, this is a point of dispute and I'm not with you on this particular point, I would very respectfully accept the point and digest it.
Okay.
However, there is more to it. And as we say in England, every little helps. So
Yes.
this is that little which helps build the entirety of the case.
Okay.
Not my point in isolation.
I hope it's not the last straw that you're grasping. Okay, go on. Just joking.
My lord, yes, my fourth point is, it must be observed with care that in this application for immediate judgment and strike out, we are only seeking to have certain parts of the defense to be struck out, because irrespective of disputes of fact, and let's say even if the disputes of facts are decided in the defendant's favor, even then we say that on points of law, they cannot win. They cannot successfully defend the claim. Therefore, there is no reason in wasting time and money in allowing the claim to go to the trial and after that coming to the same point where we can come now. Lastly, my lord, if I can please once again make, and this is the closing remark, we started off by referring to this, my lord, and let's finish it by referring to this once again. It's page number 575, please.
Yes, 575.
575, yes.
575. Yeah, 5.
And my lord, it is 44.19.
And just like, wait. 475.
Sorry, 575. 575.
575. Yes, I got to 575.
Yeah,
Real prospect of success.
That's right. So there are two reasons. Number one, permission to appeal may only be granted where the lower court or the Court of Appeal considers that the appeal would have a real prospect of success. Now here, it's real prospect. It's not certainty.
No, of course not.
And secondly, well, the point is, my lord, even if I fail at appeal before the full bench,
yes,
that does not stop your lordship granting me permission to appeal to the Court of Appeal. As I understand, from many jurisdictions, including England and international financial jurisdictions, the success ratio at appeal is around 50% at the substantive hearings.
That's fine. I thought it's less than that.
Yeah.
Okay.
Yeah. Regardless of the statistics at DIFC, this is the general reading. So the point is, if your lordship finds that there is at least some breath of realistic prospect in any of my 5 grounds of appeal, and I say that each of those 5 grounds not only have realistic prospect of success, but each of them raise compelling reason for this appeal to be heard, because the DIFC court has not yet had an opportunity to give an authoritative ruling on that.
But I will think it over.
My lord, sorry, I missed it.
I'm attracted by that submission, I said, but I'll think it over.
I'm grateful. So, my lord, my submission for all of these points is that the threshold for granting permission to appeal must not be lifted so high that it becomes a question of almost certainty for me to persuade your lordship today to allow me to go before the full bench and
Yeah,
give this consideration.
yeah. What's passing through my mind is, even if you go to trial, you can still raise all those issues at trial.
My lord, yes, yes.
Only argument against that is, why waste time of going to trial, having calling witnesses, spending a few days before we can make a decision, when we can make that the same decision today. That's what you're saying.
And also, my lord, there is another reason, which is a subtle reason, and the subtle reason is this: that this striking out provision and provision for immediate judgment is there for a very good reason.
Yes.
It's not only in DIFC, it's in ADGM courts, it's in Singapore International, Kazakhstan, in the UK Commercial Court. The good reason is, well, the point is that if every case can go to trial and can argue points at trial, then the good reasons behind this strike out an immediate judgment shall die its death. So for that pragmatism, the court must be vigilant in not refusing permission to appeal at the Court of Appeal stage, where we can persuade the Court of Appeal, or at least we have a potential to persuade the Court of Appeal that, look, apply strikeout and immediate judgment to this case, or you may apply. That is what I have before your lordship today. Unless I can give any further assistance to your lordship.
Are you saying that if you succeed on any of the 5 grounds of appeal, you will win the appeal in total? Is that what you're saying?
Indeed, my lord. I have 5 arrows attached to my bow. All I need is 1 arrow to hit the bullseye.
Okay. Okay. Yes.
That's it, my lord. Unless
Thank you very much
for assistance.
Thank you very much. I suppose you don't have a right of saying anything, Mr. Patrick, except with my permission.
Chief Justice, if I might have your permission to refer you to one paragraph of COPL, which I think will be of assistance, and it's literally to refer you to that paragraph.
Okay.
It's at page 1322.
Page 1322. COPL.
Yeah. And it's about a little more than halfway down the page. It begins an overriding principle.
1322.
1322. 122.
Okay. 1322. Okay, 1322. Where is it?
It's almost a little over halfway down, the paragraph beginning an overriding principle. And it says an overriding principle can be gleaned from these and similar cases. Federal bankruptcy is offended when the non-debtor party seeks enforcement of a cross-default provision in an effort to extract priority payments under an unrelated agreement. A creditor cannot use the unrelated agreement. A creditor cannot use the protections afforded by this statute in order to maximize its returns by treating unrelated, unsecured debt as a de facto priority obligation. Thus, where the non-debtor party would have been willing, absent the existence of the cross-defaulted agreement, to enter into a contract that the debtor wishes to assume, the cross-default provision should not be enforced. However, enforcement of a cross-default provision should not be refused where to do so would thwart the non-debtor party's bargain. And that is even on Mr. Iqbal's reliance, an issue of fact and law would have to be inquired into on the facts.
Okay, Mr. Iqbal, to be fair to you, I'll give you your last say. You're going to have the last say.
I'm grateful, my lord. Page 1656.
I like this. 1656. 1656. Yes.
My lord, these are my skeleton arguments, and
Yes.
this you can see paragraph number 69.
Para 69
of my skeleton, and then your lordship can see that I have quoted exactly the same paragraph in my skeleton and overriding principle.
Yes. And what did you say? The court examined a number of cases. The court held, blah, 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 blah. The court analyzed cross-default, court analyzed, and the court enforced cross-default, da, 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 da. What did you say to that? How does it not apply to your case?
Paragraph 69, and then you can see courts have refused to enforce.
Yes.
And then the next paragraph, an overriding principle. That's what Mr. Patrick Dillon Malone quoted.
Yeah,
However, it's a
yes.
mistake. It's a mistake to stop only at that paragraph. Please have a look at my paragraph number 70 of my skeleton and 71.
Indeed, the documentary evidence that the note, okay. An evidence by transaction, the agreement. Yes, okay. I know that.
You can see, yeah, the note. Yeah, it says the note, according to affidavit, is another essential part of the bargain.
Okay.
The third line, essential part of the bargain. And if you look at the paragraph number 71, there is another extract.
As evidence by the transaction documents. Enforcement.
See,
okay.
The consulting agreement was a fundamental part of the transaction. In this case, we say brick oven could never be fundamental part of the transaction because it was not even incorporated when the heads of agreement were signed. Whether they were signed on 1st of July 2016 or 12th of April 2017, because brick oven was incorporated 3 months after 12th of April 2017. That is the reason we say that this case must be allowed to go before the full court.
Okay.
Thank you, my lord.
Okay. Thank you very much. Thank you very much for your very, very enlightening, very useful points that you have raised that would help me to make a decision. Thank you very much.
Thank you. I'm grateful, my lord. And have a very good day. And to Mr. Dillon Malone as well.
Same to you.
We're very grateful to you, Justice. Thank you.